Mr. Speaker, thank you very much for allowing me an opportunity to respond. And I would, sir, out of two circumstances, deference to the time, we've been working back to back for these 2 days, and also to be able to have an opportunity to socialize as we go perhaps into recess. I'm not sure there is another sit-in before the recess, that we would participate in our usual convivial interaction before we go off to the recess, that I would not exploit any time that may be available to me, though I know, listening to Your Honor's conclusion, reading the time of 38 minutes, that time is not necessarily, length is not necessarily quality or substance. And sir, I want to say this, that the Honorable Anil Nandlal, the former Attorney General, has resorted to what I consider intimidation. That he thinks that if the honorable member, that is, thinks he will go to court, then we would be intimidated and we'll be deterred from doing what a government ought to do, which is to legislate in the interest, in the public interest. And this debate has seen, unfortunately, a rather unfortunate development where political and vested interests took control of the opposition side of this House, and all they were interested in was not the content of the amendment, but whether they will be dislodged of proprietary, as they claim, proprietary interests or proprietary rights. And of course, it must come as a surprise to all of us. Perhaps, in a sense, I'm elated to have discovered that my lifelong friend and political colleague, the Honorable Clement Roy, is in fact a media magnate in Guyana, mogul, a media czar. I didn't know that, and I want to congratulate him that he had not celebrated this auspicious occasion with me, because I've heard it being said that the television media, the radio medium to which he is the proprietor, has locations in almost all the regions of Guyana. So it seems as if the proprietary interest has outweighed the consideration of the bill on its merit. And coming to the House and presenting all kind of juristic hypotheses of what could happen in the court, in fact, shouldn't intimidate a forum as high as the National Assembly, which is sometimes referred to as the High Court of Parliament. So I concede that if there are any valid contentions that could entertain the interests of the judiciary, then the judiciary should be allowed to adjudicate on matters on their merits. And therefore, this is not the forum where these threats should be made as to where we will go and what we will do tomorrow or the day after or ever. What I wish to say is that the premise on which the argument has been made, that these amendments violate the law, is totally without merit. Exactly. Unmeritorious. And here it is that you have in the principal act, the substantive law that I refer to, Act number 17 of 2011, Broadcast Act 2011, and I did refer, sir, to the act having been given, assented to, by the then Excellency Barry Jagdeo on the 27th of September 2011. And he was, His Excellency then, was the Minister of Information. It was in his name that we have this act. And therefore, in the same way that you have many acts in the world referred to as the Brady Act, and we can name dozens of acts named after people and personalities, so too I have decided to simplify references between the act and the bill to give it a name. And I hope that it is not, the honorable member wouldn't feel that he is unworthy of being attached to this act. And for that reason, I am very disappointed that the author of a piece of legislation the pursuit of its further development has brought us to this honorable House by way of tabling amendments would have been absent for whatever reason. I'm very sure, very valid reasons, not here to defend certain principles that have been enunciated in this act. And when I say that the act has had a history, I want to place on the record, sir, because we must not knock this act down as undesirable. I had said in my presentation of the first reading of the debate that there are features in the act that one would recognize as positive and needed to be enlarged and to put flesh on those areas that I refer to as the lacuna in the law. But the history going back over the last 20 years would show that the evolution of this Broadcasting Act had placed Guyana in a very enviable position of benefiting from some of the finest minds in the area of broadcasting and communication. And I want to start with some of those persons who since 1992 had come to Guyana to offer assistance. Rafi Khan. He's a celebrated broadcaster who later worked with UNESCO. Hugh Chamley, also a legendary broadcaster who was once the CEO of the Caribbean Broadcasting Union and also attached to UNESCO. There was a gentleman, I couldn't remember his first name, Mordecai, Jamaican born, lived in Canada, worked with the Canadian Broadcasting Corporation, who came here upon my invitation to participate in the drafting or crafting of a broadcast legislation that would be modern for Guyana. Enrico Wolford, who had worked in the communications area for many years and was one of the early founders of what was then the GTV, now NCN, and a person with whom I have had not so friendly encounter from time to time because of political, the political divide that unfortunately characterizes our country. Mr. Kit Nascimento, who himself had done a previous draft, an earlier draft that went back to the 70s of what he had considered to be a Broadcasting Act. So that when this act came into being, it was not that from a lack of will of many people in Guyana who wanted to end what I said was a cowboy regime of people squatting on the spectrum and operating television licenses without any permission. And it was still since then that it was recognized that we need to bring some lawful control over what was then a telecommunication or a broadcasting jungle. And so there must be good reasons why in this bill, I will come to that in a while, sir, if you permit me. There were certain sections to the bill that have been preserved as very valuable to our democracy. But when the bill suffered deficiencies, and so in order for these deficiencies to be corrected, it was necessary for amendments to be made. Reference had been made before that if this Act, 2011 Act, if unlawfulness had inhered in the Act, then it would have been taken to court before. No one, particularly a government that had presided over broadcasting since 2011, guided by an act of this Parliament, would have felt comfortable that it was presiding over the broadcasting landscape with an act that was either deficient or an act that was unlawful, unconstitutional, and violate international convention and international treaty. I would have thought that that government would have impugned itself for having allowed itself to be guided by an act that lacked validity or legality. So that those who came here with an argument to say that the act which is now being modified or amplified to give certainty, in fact, that the attempt to modify the act constituted a travesty of justice and introduced a dictatorial impulse within the law. But these amendments, just like the Principal Act, didn't come willy-nilly. There was a previous broadcast authority that sat for a long period and a lengthy period under the chairmanship of Mr. Leonard Craig, including Mr. Anthony Vera, himself a broadcasting proprietor, veteran journalist, and a dear friend of mine, Victor Insonali, attorney at law, Abiola Wong Innis, the well-known Jocelyn Josiah, who worked with UNESCO, and Mrs. Amina Ghafour, well-known in her capacity as a person in the literary field. I want to say this, that this first board started to deal with guidelines authorized by the Principal Act to regulate broadcasting in Guyana. Broadcasting must not only be about collecting of fees. Broadcasting could not be that you have regulations that set certain fees, $2.5 million. It is not a good law if all that you sought to do was to exploit it for certain, I would say, kleptocratic impulse or passion to collect money. It was about regulating the content regulating the way broadcasting should be done. And the second board comprises Mrs. Lester Sobers, Justin Josiah, Dr. Rovin Deodat, Attorney at Law Joel Edmond, Arita Campbell, who once worked in these honored chambers, in the catering, from Mabaruma, Scheherazade Khan, and Bibi Safura Sadiq, representing the opposition People's Progressive Party Civic. They came as a second board, during which these recommendations were made for amendment to the law. And I want to thank them all. But I also want to say this, for the record of the Parliament, that yes, when the first board met and they were considering regulations for the Broadcasting Act, that certain problems arose that required a board of inquiry. And I want to say that the two persons who were named as subject of the inquiry, that they were exculpated fully, 100%, that they had committed no act of corruption. And I want to place this in the record, because one member thought to use the license and the protection of parliamentary privilege to cite the names of two members who are citizens of quality and who had had years of experience in broadcasting and whose work towards the improvement of the broadcasting legislation had been done in good faith and to the best of their ability. So the Commission said that there had been no act of malfeasance or corruption on their part. And so I also want to say, for the record, that the consultations, and I want to reiterate, that is authorized by the Act, is a consultation with the Frequency Management Board and with the Guyana National Broadcasting Authority. And those consultations took place, and I want to thank Mr. Valmiki Singh, the coordinator of the National Frequency Management Unit, and the members of the board for having had lengthy discussions and several drafts. In fact, 5, 6, 7 drafts of these regulations were sent to me. And so they did work very hard, as well as members of the Parliamentary Legal Committee of the Attorney General's Chamber. They have worked also very diligently in crafting these regulations that took the form of an amendment to the Act. Now, Mr. Chairman, the last speaker, the Honorable Member, Mr. Anil Nandlal, told us again, trying to create a scenario that the amendment was intended to revoke licenses to which he attached a proprietary interest. I'm not going to, I would not have an excursion into the legal arena, because it's very speculative and it has, as I said, no merit. But this is the act, the principal act that provides that the authority, the Guyana National Broadcasting Authority, not the minister. The honorable member said that the minister is trying to exercise legislative control. But I want to say it is the authority shall amend any conditions of a license on application of the licensee or on the authority's own motion. It can do so on its own. So this argument that the amendment is to tinker with and to curtail or to abridge the right of any licensee is totally without merit, that the minister will do so or the government will do so in its own authority and right this authority set up under law, which includes a member of the opposition, is the authority that will do that. And then under section 18, 1C, E, it has the power to suspend or revoke any license. So where this language is coming that the amendment is introducing this notion of revocation and suspension of license, it is a fiction. It is purely a work of an infertile imagination that you could come here and you could read. This is the principal act, and this is 18.1. And then, of course, they have, yes, the 18.1C and 18.1E, they deal with suspension and or revocation and to amend the license. In everything, the law, the principal act that I refer to as the Jagdeo Act, is saying that the authority in its deliberation to grant licenses shall be guided. And grant here also would mean, inter alia, suspend or revoke or amend, be guided by considerations of national sovereignty, public safety and order. So this was set out as the backdrop in which these measures can or may be taken. And so to impute that there is a priori a political motivation on the part of the government to present these amendments is a very, very wild imagination, an unruly horse that has bolted from the stable of reason. And so we come to the point, sir, that we were told that we came here arbitrarily and that there was no consultation. I said this morning, earlier today, sir, that the consultation, I never said that there was consultation on a bill. In 2016, there had been continuous and ongoing consultation with operators in broadcasting on aspects, concerns, and part of that had to do with giving information and having discussion, not me, the board. That's the competent authority, should have consultation with the operators or licensees. But I have something to say about that. But more than that, I read the minutes, and members of the opposition stoically, stubbornly, if I may say so, or righteously, if they may want to put that word, hold on that there was no consultation, in spite of the fact that I read the minutes of the meeting that was held in March of 2016, that was generated by the National Broadcasting Authority, not by me. And I will lay it over for the record to show who were there. And then we were told that by the Honorable Member, Mr. Anand Nandal, that he had spoken to all the operators. And they're all indignant that they had not been consulted. Well, I have here today, in today's statement issued by Mrs. Savitri Singh Sharma, the proprietrix of Channel 6, CNS Channel 6. And she said that we don't have any problem with the amendments because we at Channel 6 have been given government time from the inception of our station. We have been given government, and not only government, but the opposition and the other political parties free airtime since we started this station. Then she says, and then they say bullyism. You're having, when one member was reading from a letter from a person who wrote, said, whoa, this is the democratic opinion of someone, and that members didn't want to hear. So I'm reading the democratic voice and pronouncement of a quality citizen of this country who operates a television, and we're told now that you shouldn't listen to that, it's an opinion. But then we were told that licenses were not granted over the last 2 years. We were told that no new licenses were granted over the last 2 years or so. But whether we give license, it is a broadcast authority that is empowered to do so. And therefore, it is the discussion that had taken place that new licenses could not be granted or considered unless the law is clarified in substantive areas as to the classes of license and the zone for which licenses could be granted, and also the conditions upon which those licenses could be granted. And the fees also had been important. And so those were preconditions that had to be settled before new licenses could be processed. But in any case, there were people known in the media world in Guyana, and credible too. Stabrook News Company, Guyana Publications Inc. had applied for a license to operate television and radio. The Kaicho News, the multimedia, I believe, had applied for a license because people who operate a newspaper were granted license. There's precedent for it. And they were never entertained. So it is not true that persons had not been applying and had not waited with legitimate expectation that their application would be considered and would be considered favorably. Why would we be thinking about Mirror being granted a license, New Guyana Company Limited, a company to which I've been attached and I worked for over 20 years. And at the last, they could not pay me gratuity after over 20 years because it was on the throes of bankruptcy, veered into broadcasting and granted a license to someone. First, Mr. Siraj, the first chairman of the board, when the application apparently was made, was Mr. Donald Ramatar, who was the general secretary of the PPP, to become the executive president of Guyana. Political control. And right here in this National Assembly, there are several persons who had claimed that they're voluntary broadcasters of Freedom Radio. And as I congratulated my friend for being the proprietor, the former General Secretary of the People's Progressive Party, a political party qualified to have a license which was given outside of the broadcast law. It was given before the broadcast law was assented to and came into effect. Therefore, it was granted arbitrarily, unlawfully, and it was void and without effect, the license. And that is why the Honorable Leader of the Opposition is not here today to be able to face the music of the criticism and the righteous indignation of Guyanese people that those licenses were improperly granted or lawfully granted to friends and cronies. And so, it is like you have a gun, sir. I don't mean you, hypothetically. And you have it loaded, cocked, and you give 11 licenses for 22 frequencies to political supporters of a political party, friends and families. You have already cocked your gun, ready to shoot your opponents. And then you put in the law that those outside of the friends who are granted license, then they should be able to grant, because you know You know the station that operates out of an antenna in Breakdam, out of Freedom House, and others, people, friends, a minister of the government was involved in getting one of the licenses. Those have been categorized already. But just to be sure, is that your political control of the propaganda that will come out of these 11 entities that you have affinity with, you decided to penalize those outside of the group. So you require all licenses to do this. They shall give a certain percentage of public service broadcasts or development support broadcasts. We know, sir, something used to be called a Mackay machine. What does development support broadcast mean? When the state media was converted into a propaganda arm of the ruling party, the PPP. I have been a minister of that government, and I have fought against the transgressions of politicizing the media. If one person, if anyone could say something about me, is that I changed the name from propaganda to public relations. And so I resisted this attempt. The press became a political broadsheet, a rag of the political party. That must be distinguished from government information, public information. But what happened in this law, they have not in this law, the deficiency is to be able to describe or to define public broadcast. So what this amendment did was to define public broadcast in such a way that you understand that public broadcast has to do with information, that programs that will be produced for all the people of this country. And in fact, it didn't do much. If you look at Section 2 of the amendment, Section 2 of the amendment says this: broadcasting service means a service providing broadcasting and includes a television broadcasting service and a radio sound broadcasting service. That's what it defines it at. In this act, in the original act, Section 2D attempts a definition. Section 2G, it says here, broadcasting service means a service providing broadcasting. It's the same. So when one member of the opposition came here and said that we repeal the sections and that we give it a narrower definition, no, we give it an expanded definition, which it lacked in the first place, which is improving and embellishing the existing law, not detracting and taking away from what it is. And if the member does not understand broadcast language, they shouldn't venture into an arena that is alien at this time. But let me come back to this point. It was alleged that, as we were saying, that one member said they spoke to so many people and that no one had really expected the application to be processed. Mrs. Savitri Singh Sharma is saying that she had applied and reapplied all the time. And sometimes, so I'm quoting from my cell phone and from a release that was issued today. I'll borrow some from you. You're a rich man now, I can borrow from you. Didn't know you're a proprietor of the station. And I even suspected that our applications were being thrown in the bin. So if this government asks us to once again reapply to regularize the system, I don't have a problem. And I know that Channel 6 wouldn't have a problem with reapplying again. Now, I want to commend Mrs. Sharma for her forthright statement in dealing with the issue that they could reapply. Why you could reapply? Because the fact that you have different zones means that now you have a right, You could choose which zone you want to apply in and you want to operate in, and therefore that right is a freedom that is granted under law. Now, sir, as I said, we didn't want to take this meeting to its logical, to strain the time factor. But if you will permit me, sir, we will have to deal with a few other issues. Now,
Honorable Prime Minister, there is a level of competition that is taking place to your right. It might help considerably if that competition subsides. Please proceed.
I want to, sir, there was mention that by one member, the Honorable Member, General Burton, that look, you didn't have to really bring an amendment to deal with hate speech and terrorist threats. And my honorable friend, Vice President Carl Greenidge, addressed that issue, how important it is. But that it is in the Act. It is also in the Constitution. And therefore, it is also in the anti-terrorist law dealing with, which we passed here and assented to. It was stated about terrorist threat. And there is no such thing as superfluous in law in trying to bring within a specific law dealing with a specific discipline. The intention of the Principal Act that there should be certain obligations attached to a license, certain conditions attached to a license. And one of those conditions, it does not hurt if it is regurgitated or repeated in an amendment to make it abundantly clear that the media, once you are licensed to operate the media, it shall not be abused, or else there is a penalty that is attached to that. The main law provides for that. And therefore, I see this excursion into saying you have to define the threat, you have to define the hate speech, and you have to define hostility against people on ground of race, etc. We are already commanded by the Constitution that we can't do that. And the scare tactic that was raised here was as if it was in fact a terrorist onslaught, perhaps not intentional, to call this bill a terror attack, to call this bill a wrecking ball, to call this bill doomsday. The amendment that is being brought here, Member Gillian Barton said here that this is Burton Persaud said, Mr. Speaker. And then it has a threat that there will be seizure of property. Well, sir, my colleagues have said, explained that the Principal Act already provides for those things. That if you have a new regime of zoning and a new regime that gives you a choice of operating a commercial broadcasting entity or a community entity or a non-commercial entity, you will have to now apply. There's an application form at the back where you'll just tick off one application fee, how many zones you would like to apply for? One fee, one application fee, and you will indicate the strength, all the technical capabilities you have, the strength of your antenna, the strength of your transmitter, the reach of your antenna, the strength of the transmitter, etc. So, sir, I'm saying that today there was a good debate, I would think, in all it was one of the better debates I've heard in the House, and I'd like to commend the colleagues on this side of the House, first and foremost. They were a formidable team, unbeatable. They beat the arguments, and the debate was decidedly in favor of this side of the House from a debating standard. And on the opposition side, I commend them also for taking a stand. They will say they have to do this for their constituency, but a stand should not necessarily be political grandstand. It could be a stand in which we could work to improving legislation and try to give the people the best this National Assembly can give in terms of legal guidance, because this is a law-governed society, and we have to make laws to help the society develop, help the society grow, and we cannot resort every time to the tactic. I brought a book here just in concluding, sir, a book that I found very interesting. Its name, Divide and Conquer, and it was written by someone who many of us know here, Barry Sokram, Clement Gale. You know, honorable members, you know this member. He referred to in this book to a letter written by the late President of Guyana, Chedi Jagan, in which he said, in reflection, I think all of you should get this book, that he had realized that you couldn't pursue as a viable political strategy one that was based on all struggle and no unity. He reflected that there was a time when he struggled against colonialism and imperialism externally. Then internally he struggled against in the party what he described as right deviationists and left opportunists. And he fought internally against the business class, the capitalist class that he defined in those times. And therefore, I want to say that in this age, Dr. Jagan then had realized that it was not viable. By 1976, 75, he had changed tactic. And he also said, unity without struggle, all unity and no struggle is harmful. He chose a line that was between, that says you have to work, what he said, for political transformation, based on engagement, based on inclusion. And that is how 1975, 1976, the issue came up of critical support, and later the concept of a government of national unity. I know it may be said here that what is the relevance to this debate? But it is very relevant that whenever we come to this National Assembly, we cannot come only prepared as warriors to fight and to fight down everything. We have to come also as builders to support constructively those measures that are intended to improve our society, intend to improve our systems. And therefore, I want to commend this bill to the House for passage, and I now ask that it be read a second time.